And for life. All right, so Senate Health and Welfare, April 25th. We are looking at two bills that have been returned to us from the House. The first one is S28, and Jen will walk us through the changes, and then we have Michelle Childs on deck in case we have specific questions. Great, right ahead.
Good morning, Jen Harvey from the Office of Legislative Counsel. I will put up, I have a markup version for you showing what you passed, like what we looked at yesterday, what you passed showing markup from the House proposal of amendment. So S28 is an act relating to access to certain legally protected healthcare services, just to remind you of our topic. And the first section is now a new section 1. This is amending the existing definition in Title I of legally protected healthcare activity to include some new language that says that the protections applicable to persons who engage in legally protected healthcare activity shall also apply to a person who has previously undertaken one or more acts or omissions while in another U.S. jurisdiction to aid or encourage or attempt to aid or encourage, that language is from the existing statute, any person in the exercise and enjoyment or attempted exercise or enjoyment, also existing language, of rights to reproductive healthcare services or gender affirming healthcare services that would have been protected by this state if they were undertaken in this state, provided that the acts or omissions were permissible under the laws of the jurisdiction in which the person was located at the time they were undertaken. Basically, this is what this is saying is Vermont will protect under our legally protected healthcare activity actions or omissions taken by likely a provider in another state if it was legal in their state and would have been legal if they had performed those services in Vermont. So some reciprocity for states with similar
the telemedicine.
Right. This could be a physician performing telemedicine services. If they come to this state, they will be protected under our umbrella of legally protected healthcare activity.
Is Sheldon being coming to talk about this one?
Yeah. This is section 1. This is the judiciary one. We go.
So I just have questions about like the interstate.
Do you want to do that now or first before you do that? Do the other sections have similar kinds of relationships that we need?
So, some do. I mean, there are definitely provisions in here that are not necessarily looking at other state issues, but looking at some.
Okay, well, let's have Michelle talk. We'll look at it first and then we'll have that understanding.
Jen also knows this.
Yes.
So. Right. So for the record, Michelle Childs, Office of Legislative Counsel, and usually next door in Senate Judiciary.
We're glad you're here.
Thanks. Always enjoy being here.
You know it wasn't. Have you been here this year?
I have not.
Oh, do you know our new senators?
We have not met.
Senator Larry Hart.
Pleasure to meet you, Jerry.
Okay. Senator Douglas.
Yep, and Senator Douglas and I met.
Okay.
Yes,
Okay.
I've been watching you that, and you know what, I just had a little flashback, if I may. So my oldest daughter just turned 18, and Senator Cummings was on Senate Judiciary when she was born, and she knitted her during that session, knitted her a beautiful blanket.
Oh my
And so I was just thinking about, she's now in college.
And she hasn't.
And we still haven't Senator Cummings blanket.
Well, she did a beautiful sweater for my daughter when she was born. We've outgrown it at this point.
Little thank you for it. So sorry for the digression.
All right, so Madam Chair, do you want Senator Douglas to ask his question?
Yes, please.
Yeah, so ignoring the topic, reproductive health and gender affirming care, the interplay between the jurisdiction with the sovereignty of the states and how the law interplays there. What other instances do we have in law in Vermont or elsewhere where that sort of stuff happens? I just don't know the law around state.
So kind of like comedy.
Like state policies that might
Yep.
reflect this.
So there's a provision in the U.S. Constitution, the full faith and credit clause, and essentially
Which clause?
the full faith and credit clause. And so generally, the idea behind that is that states are to give full faith and credit to the acts and the judicial orders from other states, and that's to so that you can kind of recognize. So if there is a court order in another state, so let's say lived in New Mexico and I got divorced and there, we have an order with regard to care and custody of our children or whatever, and then we all move over to Vermont, then the state would recognize that judicial order from New Mexico. With regard to judicial orders, that's kind of like the states must comply and acknowledge the orders that are issued by the courts of other states, with some very limited exceptions. So when there's a court order, you have to obey the court order. That's just how it is. When it comes to recognizing the laws of other states, when your state law may be different, generally states do recognize other states' laws, even though it may be different. One thing that comes up for me, because I do a lot on family law, people will say, oh, do we have common law marriage here? Or do we allow first cousin? Or just because states can be a little different on the marriage laws. And when it comes to recognizing another state's laws, there's more room there for like your state to say, you know what? The policy between the two states is really different and diametrically opposed. And so in those circumstances, a state can say it is against the public policy of this state to recognize that other state and apply that other state's laws here in Vermont in that particular situation. And so there is what's considered what you call like a public policy exception there. And so when you're talking about the Shield Law and the acts that were passed, Act 13 and Act 14 in 2023, that's where a lot of it came from, which is that, Vermont stated several times in both those acts that it's the public policy of the state to protect folks who are either seeking certain type of care, of health care, providing that care, or facilitating someone else being able to get that care. And that in cases where there's another state that, and there's a state interplay there, Vermont's going to use its law and is not going to recognize the other state's law.
Last time we did this, you'll hear on the floor why it's act today, was civil unions or same-sex marriage, that we had people that came here, but in their home state, and before that, it was interracial marriage that was not allowed in some other states. So you could get married here, you could get arrested when you went home. But
right, and that was an example of at the time. And I saw Bill and Tom before or something. I'm gonna be out on the floor there because I was counsel for civil unions at the time. And is that case, Vermont was the first state in the country to do kind of like a parallel system to marriage, but not marriage. And a lot of people came from other states to get a civil union here in Vermont. And the question was always, well, when I go back home to California or New Mexico or whatever it is, are they going to recognize it? And we said, we don't know. That's not up to us, right? All Vermont can do is pass laws that affect the people who are here. Is it legal here? Will it be recognized here? But once you leave the jurisdiction, we don't have any control over whether or not that other state is going to recognize it or not. And so it was kind of patchwork. And I remember we had in the bill kind of almost like, I don't know if I call it like warning language, but like on the application, when you go to the town clerk for us to get your civil union license, it would say, kind of a disclaimer, kind of just letting you know, if you are not a resident of Vermont, when you go back home, this may not be recognized, but will always be recognized here in Vermont.
so given that, if we look at the language that's in section 1, can you walk us through that language and explain what that means? Because the word previously to is important, and then what it means throughout.
So I think the reciprocity piece that is new here addresses. So there are, I'm not going to remember, I don't have my little list, although maybe I have it there in my file. So there are
We're not the Judiciary Committee, which is
okay. I think there are 18 states that have some type of shield law with regard to legally protected healthcare. And so, so this new language is looking at providing some reciprocity in those protections. So an example would be if you had a New York healthcare provider, and they are protected. You know, they've provided services in accordance with their license that are all, you know, covered by New York law, and they're protected. But again, this idea of thinking about civil unions, right? Once you leave that jurisdiction, right, New York can't do anything to protect you. And so what this new definition in B4 is doing is saying that if you are protected in your home state and have engaged in conduct that is legal there, which would also be legal here if you had engaged in that conduct here, then we're going to afford you the protections.
So it's the states that have the common statute.
Right. So going back to that idea of
Not
comity, not
Protecting
comity,
anybody in a state where
Right.
it's different.
Right. So if the public policy, essentially, if New York and Vermont's public policy is the same, we're going to recognize that and we're going to provide reciprocity.
Isn't that kind of a given? And I'm not asking that to be, you know, glib or anything, but is this just strengthening what we would consider the REV?
No, because the existing definition is applying to people who provide the service here
Mhm.
or obtain the service here.
Mhm.
So the New York physician provided that service in New York, right? Or in the cases, because telemedicine is covered in these circumstances, if that New York physician provided telemedicine there, or they had a college student who was their patient normally in New York, but that student is going to University of Texas and they, you know, provided care to them through telemedicine. It was legal in New York. That conduct would be legal in Vermont, but Texas, it's not legal in Texas, right? So New York's not going to recognize Texas's claims. And this says Vermont wouldn't have to recognize that either, because what you may have in circumstances that there may be in Texas, there may be issued a warrant out for that New York provider, right? They're covered and they're addressed in New York, but they cross over to Vermont and they're going to their friend's camp or they're going
Thank
skiing
you
for the
clarifying
weekend.
that.
And if they got stopped for speeding or something like that, and then it pops up and it's like, oh, there's a warrant.
Yeah.
This is a real thing. I
Yeah,
mean,
this
we
is-
did hear from a
That-
provider
that's-
who indicated that she's very careful about where she flies, which airport she lands in.
Yeah.
So she's not in a state that doesn't have the same laws as New York or Vermont.
Right.
It's really concerning.
Right.
Yes.
But again, it would have to be, it's not protecting anybody whose conduct would not be legal if they engaged in it here too. So it's just saying we have, to the extent there's that overlap where Vermont law and the other states' laws are the same in that regard with the provided protections here.
Yes. Thank you so much.
That answer your question, Sylvia?
Yeah, I just don't know how the laws.
All right, and that's actually in section 2. So now we're no changes to the Public Records Act exemption that was added. A small change in section 3 on unprofessional conduct. This is in the context of the Office of Professional Regulation statutes in 3 VSA section 129. There were some things that were that you had added around advertising, delegation of professional responsibilities. In this committee, we had put in language saying delegating professional responsibilities to a person whom the licensed professional knows or has reason to know is not qualified by any combination of training, experience, education, or licensing credentials. And at the request of the Office of Professional Regulation, after further consideration, they had concerns that this actually weakened their authority to provide discipline for somebody who,
But where,
we're on page 3. We're in what is now section 3 VSA 129, unprofessional conduct. And what constitutes unprofessional.
I'm looking at I got it. It's just not marked in the calendar.
In the calendar, it's just not in there.
Yeah.
So I'm showing you the markup version, which includes language that's taken out. So if you can see in the
Okay, got it. Oh, it says it.
screen,
It has it. It says it says or any combination of items. It's here.
Any combination of item, where are you?
Well, we're at number 6. Sorry. I mean,
Okay,
I was looking at A, my fault,
okay,
bad.
great, okay. Should not be there, because that's not what that's. All right, then we have section 4, which is the expanded language around the Consumer Protection Act for information about healthcare services that is false or misleading in advertising. No changes, a change in the definition of healthcare services. I think from a practical standpoint, I don't think the intent is different, but this is using similar language to the definition in 1 VSA section 150 that we were looking at the beginning of the bill in existing law. That's kind of the broadest possible definition, and you'll see this same change being made in S27 when we look at that as well. Broadest possible definition of healthcare services. So it's very similar to what was in the Title I definition, with the addition of dental. We had not included in the legally protected healthcare definition because it wasn't relevant. So that is change in the definition of healthcare services, but again, really more to ensure that it is as broad as possible, but not to make substantive changes. Section 5 is another new section to the bill. This is in Title 12. This is an existing provision that was passed as part of the Shield bills 2 years ago on non-cooperation. So this is some of what Michelle was describing about when Vermont would not cooperate with an investigation from another state. And under existing law, it prohibits any public agency or employee, appointee, officer, or official, or any other, and we're just being clear that by person we mean individual, acting on behalf of a public agency from knowingly providing any information or expending or using time, money, facilities, property, equipment, personnel, or other resources in furtherance of an investigation or proceeding. In this case, we're adding federal, so not just interstate, which is what was in the language from 2 years ago, but also a federal investigation or proceeding that is seeking to impose civil or criminal liability upon an individual or entity for the provision, seeking or receipt of, or inquiring about legally protected healthcare activity that is legal in the state, or assisting any, and change to individual or entity, providing, seeking, receiving, or responding to an inquiry about legally protected healthcare activity that is legal in this state. And then I'm going to show you some new exception language. But first, I just want to flag really the only substantive change in this piece is the addition of federal for the person, because the definition of person in Title I includes individuals and entities. We're being more specific about an individual who is doing the acting up here, and then when it had said a person or entity, to be clear that it's an individual or entity, which is really the whole person definition from Title I.
Just looking at Michelle. This is okay.
It's fine. So as Jen mentioned, this is not interfering with another state's actions or the federal government. This is just saying if it is contrary to the policy of the state of Vermont with respect to legally protected healthcare, we're not going to assist you with that. So we're not going to, devote some, state resources, either in terms of personnel or time or money or anything like that with regard to that. And so feds cannot compel us to assist in those matters unless it's specified either by an act of Congress or by a federal court order.
So this is explaining then what the section does not apply to, and in existing law and not changed, there's no non-cooperation provision where the conduct that's subject to potential liability would be subject to liability under the laws of this state if committed in this state. So if it wouldn't be okay in this state, we're not protecting anyone. Any action, and under existing laws, is any action taken by the judicial branch and judicial proceedings. This language, I think, was modeled on another state, and so in communications with Vermont's judiciary, we've modified that to say any order issued by a Vermont state court. And then, new concept is adding or a federal court. So this section does not apply to an order issued by a Vermont state court or a federal court. And then in 3,
So can I just mention on that? So that goes back to that issue I had mentioned earlier, which is that if it is a court order, the state is required to adhere to that order. You do not have the option to ignore a federal court order.
So it would be great if all elected officials followed that.
and so in making sure we're not putting anybody in Vermont in a difficult situation where the law says don't do something and the federal court
Right, you
says
don't want
do
you
something.
don't want an
we have this
employee to
exception.
be found in contempt.
And then this is some conforming language in 3, again, with the exceptions, a public agency or employee, appointee, officer or official, or any other individual acting on behalf of the public agency, because that was the language used at the beginning. So an exception if they are in the course of normal business responding to a warrant or extradition demand on the good faith belief that the warrant or demand is valid in the state. That's not really a substantive change.
And that provision just relates to if there was a warrant in the system and law enforcement officer, it's not apparent to them that it's a warrant that would not be recognized in Vermont, based on legally protected healthcare, then, and they act on that warrant and temporarily detain the person, then that's no fault of the office, the person.
Okay, so it's protecting the person that's issuing, acting, serving.
Right, because it may be that upon that initial first look, without delving into the case and the circumstances, it may not be clear that that's not a warrant that we're not recognized.
All right, section 6 is also a new section, and this is amending law that prohibits disclosure of some protected health information. So again, amending existing law, some of which was updated in the SHIELD bills from 2 years ago. Under existing law, there's a bunch of definitions, most of which track the definitions in HIPAA, the Federal Health Insurance Portability and Accountability Act of 1996. And then a couple of other definitions just referring to Vermont law. So under existing law and not changed here, a covered entity or business associate shall not disclose protected health information unless the disclosure is permitted under HIPAA. But then we have a notwithstanding any provision of subsection B to the contrary, in order to protect patients and providers who engage in legally protected healthcare activity and except as set forth in subdivision 2, a covered entity, that's an entity that is covered by HIPAA, or business associate is another individual or entity with whom they have a professional business relationship in which some protected health information may need to be shared. So a covered entity or business associate shall not disclose protected health information, and this adds, that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity, to any government entity other than the state of Vermont or its political subdivisions or instrumentalities, if the covered entity or business associate has reason to believe that the information will be used to conduct a criminal, civil, administrative, or professional disciplinary investigation into any individual for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity, or to impose criminal, civil, or administrative liability or professional disciplinary action on any individual, again, for the mere act of seeking, obtaining, providing, or facilitating a legally protected healthcare activity, or to identify any individual for any of those activities. So just to recap this one a bit, a covered entity or business associate is not allowed to disclose protected health information that is identifiable or susceptible to re-identification and is related to a legally protected healthcare activity, to any governmental entity other than the state of Vermont, if they have reason to believe the information will be used either to conduct an investigation or to impose liability on somebody for the mere act of seeking, obtaining, providing, or facilitating legally protected healthcare activity.
Go ahead, that's my question.
Okay, so can't be used for that, also cannot be used, and this is existing law, for use in a civil or criminal action, proceeding preliminary to a civil or criminal action, or a probate, legislative, or administrative proceeding. And in current law, it says unless, and there's a list. We're gonna keep similar list, but in this case, it's just ending there and saying notwithstanding subdivision 1, a covered entity or business associate may disclose that information if the disclosure meets one or more of the following conditions. And from the existing law and maintained here, the disclosure is authorized by the patient or their legal representative. Striking out the disclosure is specifically required by federal law, Vermont law, or rules adopted by the Vermont Supreme Court, although that shows up here. The disclosure is ordered by a court of competent jurisdiction pursuant to federal law, Vermont law, or rules adopted by the Vermont Supreme Court. And it clarifies that a state court order compelling disclosure must include a determination, and under existing law, that determination is that good cause exists to require disclosure of the information. And this would change that to a determination that the information will not be used to impose criminal, civil, or administrative liability or professional disciplinary action on any individual based solely on the fact that they sought, obtained, provided, or facilitated a legally protected healthcare activity. Also, an exception for a disclosure that's to be made to a business associate designated by the covered entity or their business associate. These are mainly just clarifying changes going to be used to defend the covered entity or its business associate against a claim against them in a legal proceeding. And then no changes other than the designation when the disclosure is to Vermont Board of Medical Practice or Office of Professional Regulation in connection with a bona fide investigation about whether somebody has engaged in the unauthorized practice in this state. Also not changing is the disclosure is to the Department of Health or DALE or both in connection with a bona fide investigation of a licensed healthcare facility in Vermont. And then a new exception subject to the limitations set forth in that non-cooperation section we looked at in section 5. The disclosure is required in the ordinary course of business of Vermont's Medicaid program. So if it's something that Vermont Medicaid has to disclose in order to run their Medicaid program, and it's not specifically to try to identify or impose liability on somebody for involvement in legally protected healthcare services, then that information can be disclosed. And then finally, there's a protection for a covered entity or business associate from civil, criminal, or administrative liability or professional disciplinary action if they refuse to disclose protected health information in accordance with this section. There's kind of a lot here.
So there is a lot here, I mean, but basically we're protecting medical information from being used inappropriately under our laws in this state. My question, and then anyone who's distributing it can't distribute it illegally or in contrary to the laws in our state. And we allow for Medicaid to distribute information so that they can run their program appropriately. Then the question I have is, someone comes in from another state and they're protected only while they're in this state, and their medical information is protected only while they're in this state. And if they go back to a home state that has a different policy, I'm going back to the full faith.
So if they receive medical services in this state, their medical information would likely stay.
And the only way it can leave is if they ask it to be transferred to a practitioner.
So any disclosures that they authorize, which may also include for payment purposes, if they have an out-of-state insurance. But if they authorize disclosure, the information can be disclosed.
Okay, so it's up to them. And if it's authorized from an insurance company in a state that doesn't have the same laws we do.
We can't protect it once it leaves the state, so they may make different choices about how they want to pay for care based on what information we're leaving the site.
All right, good. Is there anything else we need to know about the, Michelle? Okay,
Okay,
a lot more, but
no
this,
changes in the next few sections. So section 7 and 8 were really some cleanup changes around definitions in Title 18, leading up to what is now section 9, which is on the fetal death reports. I guess the one change, there's a wording change here on page 17, House Healthcare Committee changed woman to patient.
oh, correct.
And then section 10 is unprofessional conduct in the Board of Medical Practice statutes. So again, we're removing this phrase about any combination of to modify training, experience, education, or licensing credentials. So that same change has been made throughout. And then also in the language about the adaptive questionnaire, this is the exception to allow a provider to use an adaptive questionnaire that allows them to obtain additional medical history and ask follow-up questions when prescribing a medication to terminate an individual's pregnancy. That the House has added that this questionnaire must be developed by or in consultation with healthcare providers with clinically appropriate expertise. That may have been an assumption, but they wanted it to be explicit that this could not just be, this could not just be an AI generated, for example, questionnaire. It has to be developed by or in consultation with qualified healthcare providers.
Yeah.
So you will see that change in section 11 as well, which is that same adaptive questionnaire language for advanced practice registered nurses. And that is on page 23. And then section 9 comes out. This is the unprofessional conduct for certified anesthesiologist assistants. And it was only in here because we were making that change about any combination of training, experience, education, or licensing credentials under the unprofessional conduct statute. So that change is not being made, then we don't need this section in the bill. Take out another section in a minute as well.
What was the reasoning behind that any combination of to begin with?
We did it.
I think it was a recommendation from the licensing boards and they had they reconsidered. All right, section 12 is licensed physician assistant, unprofessional conduct, no changes here. Section 11, there are some changes. This is around the confidentiality of information on the prescription bottle or packaging for.
Okay, can you remind me why we went to section 12 again? And because it was all the different professions and now we're going back to 11.
Oh, it just means I messed up the numbering.
All right, that's what,
And trying to give you the markup version.
is that a technical correction?
It's not even, it's just for the markup. It's
Ah,
fine. Numbers are right in the bill.
we don't want another short.
All right, so section 11, for confidentiality of prescriber information on medications for legally protected healthcare activity. You can see a little preview of what's coming in the section. They've added and pharmacist in the section heading. We've got another definition as well. So we're keeping the definitions that were in the bill as you sent it out, just referring back to 1 VSA section 150, but adding a definition of non-controlled medication, which is a medication that is not a controlled substance under federal law. And then a few changes here, as you may recall, when the bill left the Senate, there was language saying that if the prescribing practitioner requested and it was not specifically prohibited under federal law, the pharmacist must not list the practitioner's name on the fulfilled medication for gender affirming healthcare services or reproductive healthcare services, but would instead list the name of the facility where the practitioner is employed or as a contract employee. Some additional conversation and testimony from pharmacists and others upstairs about some of the practical difficulties in this. Language has changed to say, again, upon request of the prescriber, and to the extent not expressly, and it seemed more appropriate to say required under federal law instead of prohibited. So not expressly required under federal law. A pharmacist and we've added, or other licensed member of the pharmacy staff shall, and instead of not list, it would be redact or otherwise remove practitioner's name or initials, which comes up more in the pharmacist context, but could be from a fulfilled prescription for, and then clarifying a non-controlled medication. So there do seem to be some requirements around prescriber name for a controlled substance. For non-controlled medication for gender affirming healthcare services or reproductive healthcare services, and for any accompanying printed materials. So on the container itself, and there's information stapled to the front of the bag, for example, that would have the prescriber's name on it. It would be redacted or otherwise removed from there as well. Similar language in subdivision 2 for the pharmacist and taking the pharmacist's name or initials off, again, for a non-controlled medication.
These are requirements. These are shalls.
If this is a pharmacist may, or upon the pharmacist's request. No, it's only upon request of the person whose name would be on the materials. It's not a shall. I mean, the first one is a shall upon the request of the prescriber. This one is a shall if it's the pharmacist requesting it of their staff.
Okay.
Pharmacist would do that.
So person comes here, sees a doctor, gets the prescription. I see how that works. If you do telemedicine, does the doctor send the prescription to a pharmacist in your home state? Or does he send it to a pharmacy here who puts it in a blue brown bag and sends it to your? How does this work?
I think there's different ways. These protections would not apply if it was filled out of state. And there could be other potential liability issues if it's filled out of state. My understanding is some are filled by mail order pharmacies, or it could be filled here and mailed. But there may be some issues if a pharmacist isn't licensed in the state it is going to. So yeah,
That's
so yes, so the cleanest is for somebody to fill a prescription here.
all right, or use a mail order pharmacy.
Or use a mail order pharmacy that is licensed in the state they reside in. Yes.
Could they subpoena that equipment or that prescription or that information in the home state?
Do they subpoena that information from the Vermont pharmacist?
Or from the mail order pharmacy that is licensed in the other state?
So if they're in the other state and that state is controlling with that particular place.
Yeah.
So we don't have the ability to, like, there's a process here when it implicates legally protected healthcare, there's a
Right.
process for quashing a subpoena
So-
because it's related to the protected health information. If it's in the other state, again,
They
No,
can, okay,
no, they
so
really
the
control.
state,
yeah.
the only safe thing is to come here, you come here, receive your care, and then go home. No one can access what happened here. It's like Las Vegas. But if one witness we had, if you prescribed over Zoom, and that prescription is filled by an online pharmacy or a pharmacy in the home state, that home state could access that information.
I mean, that home state's laws
Right,
would
would be
apply
controlled.
as far
Okay.
as what can
Right,
be
okay.
dispensed in that state, as far as who has to be licensed to dispense in that state.
Think of something else. I mean, potentially, the prescription could be made in this state, and the pharmacist might say, sure, I'm glad to do that, and I'll mail it.
Yes,
So the mail would,
Right, but the mail, when it go, I mean, I
Well, it's
believe
right
it's
there.
considered dispensing in the other state, it's being mailed
Exactly.
from here, so,
Right.
and they would have to be obeying the laws in the home state.
so we couldn't say.
So, yes, so there may be.
And they're legal to discuss that.
So we may not be, Vermont protections would not apply. That would be a decision for the pharmacist or prescriber to make.
Understand this is.
Right. All right, and then we have similar language as well for a prescribing practitioner who dispenses medication directly to patients. For gender affirming healthcare services or reproductive healthcare services or both, they can also redact or otherwise remove their own name or initials before giving the medication to the patient. And then in the languages you sent it over, there was some provisions specifying that nothing in this chapter or rules should be construed to require a pharmacist, this adds, or other licensed member of a pharmacist staff to list the prescribing practitioners. We've added or pharmacist's name, added or initials on a fulfilled prescription for, and also added a non-controlled medication for these services.
Oh.
And then new and of interest to the committee next door is subsection D that provides immunity from civil and administrative liability for the pharmacist or other licensed member of their staff if they fail to redact or remove the name of the prescriber or pharmacist when requested to do so, provided the immunity does not apply to gross negligence, recklessness, or intentional misconduct by the pharmacist or other staffers. There was some concern from the pharmacists, especially with different e-prescribing systems and otherwise, that they might inadvertently miss a request to redact a name. And they were concerned about the liability if that was ordinary negligence. And
It's kind of hectic in a lot of pharmacies. Tenants sometimes have teenage.
Yeah, I was waiting for some.
Yeah, no, you're fine.
For intentional misconduct, what if somebody, like it's a pharmacy staff and if they put the name on it, when pharmacist requested the name not be on it, and it was an accident, but the pharmacist like thinks it wasn't an accident or just doesn't like the staff member for whatever reason and says, "Oh, you did that on purpose." Like, what would happen then? What's the measure of intentional misconduct? Like, how do you prove that?
So intentional misconduct is just that it was an action that was taken that was intended to cause the harm. So I think what you're talking about would just be more of a situation of ordinary negligence, right? So that's like a failure to exercise reasonable care. But what you have in here around, which is like the standards like gross negligence, which is like a higher standard. So the language here works in a way that if somebody makes a mistake, then they're not going to be liable under this provision.
But if they have a record of not approving these kinds of procedures, and they intentionally leave the names on it.
there could be little liability. Again, it's civil or administrative liability. So this would require somebody to file a complaint.
And then the plaintiff would have to allege, these are the reasons why it meets this standard. Because they have been vocal in their opposition to this provision. They have on other, a number of other situations have failed to comply with the provision.
Said they're not going to do it. Right. All right, section 12 is another one that is just out of the bill entirely. This is the conforming change around the combination of for certified radiologist assistants. So not qualified by any combination of, with that language could be out the whole section. As finally, the act will be effective on passage.
I did a lot.
Yeah.
Did a lot.
Double one.
Yeah, they did a lot.
Well, some of it will come out, this issue.
Feels like the lawyers got all the control. Okay. So committee, we've been through it. Any reason why we should accept the recommendations as they've come to us from the House? I mean, some of it we'll hear from Judiciary on sections 1, 5, 6, and 13, which is also under their jurisdiction. But as far as the other pieces, protecting the pharmacist, for example, making sure it's we're adhering to our state laws and following federal court orders. Those things are secret.
Yeah, I'm sorry.
Okay, that's right. I'm good.
My only reservation was just the length of it and I mean, it was a great walkthrough, thank you, but it was only 20 minutes and all, basically, I a bill.
Well, this is how we do it. You know, give your strong vote. Let's just do a strong vote then for consent. Approving, that's it. I mean, we don't do so. So I'm willing to. I'll see what I can do to present it on the floor, assuming, of course, that judiciary has an opportunity to go through it. If they haven't, we'll pass over it, and that'll give us some more time to also consider word changing. We don't need a conference committee on this. It's all.
You want to delay S27 to next
No,
week?
I really would
Wanna
like
do
to
it
go
now?
through with it. Yeah, and we also have 401. And the 91 is kind of the one that will be spending much more time. And so I want to try and, if you have
Your
time,
lives.
it's yours.
I think so. Do we know when we're over?
I'm gonna go pop Nick
Okay.
and see where they are on the charter
This one
change.
should be quicker.
Okay, all right.
But, yeah,
Shorter bill and fewer change.
okay, so can we get? Oh, 30 days back. Annie's as good as Kiki, don't tell him I said. If you get one of the legal cups for the floor, I have been told that if you put warm water and dissolve a cough drop in it, then you can sip it. And I'm not allowed to have one. I had it last year. I can't have it this year until it goes through rules. Why? Until it goes through rules. You can't talk. That's good for everybody else.
You are still live.
All right, you're still on. Okay, so we are on to S27. Just make everybody feel.
All right.
As Jenny, thank you.
Ready? Sure.
S27 is what?
S27 is an act relating to medical debt relief and excluding medical debt from credit reports. This is the bill that the treasurer's office brought to you. It still appropriates $1 million to the treasurer from the general fund in fiscal year 26 to contract with a nonprofit entity to acquire and repay certain medical debts. Incurred by Vermont residents.
They're coming back. They took a break for us and they're coming back at 10:45 to do estimation.
Oh, this is perfect timing, I think.
All right. There are certain requirements that for what the treasurer must ensure that the entity with whom the treasurer's office contracts will do. So no changes to what you've sent over. Purchase the medical debt of eligible debtors from healthcare providers at fair market value. Abolish it with no cost or tax consequences to the debtor, and coordinate with the healthcare provider or collections agency to make sure anything on the credit report about medical debt comes off. And then this adds an additional provision, and I'll just, before we go through the language, give you the concept here. House Healthcare wanted the individual to be, to know what medical debt was abolished, but also to understand what the patient financial assistance policy requirements are in statute, so that in the future, if they're financially eligible, they may be able to benefit from those instead of incurring additional medical debt. So that's what 4 here is, to notify each individual whose medical debt was abolished pursuant to this section. First, the amount of their medical debt that was abolished and the name of the healthcare provider or providers from whom the entity purchased the individual's debt. So which debt was canceled and abolished, and the estimated percentage of the federal poverty level that corresponds to the individual's household income, so that they can understand. You can see where it says that financial assistance policies are available at all Vermont hospitals in accordance with existing law, including the following minimum discounts. And again, these are discounts that are already established in state law. It's just informing the consumer of them. So it's 100% discount for individuals with household income at or below 250% of the federal poverty level, and at least a 40% discount for individuals with household income between 250 and 400% of the federal poverty level. And as you may recall, the eligibility for medical debt repayment under this bill is somebody whose household income is at or below 400% of the federal poverty level. So it's providing some additional information then what debt was abolished, what their federal poverty level is for their household, and then the availability of financial assistance policies at all the states.
So this is language in statute. I was trying to remember if this is the exact language from statute.
What, the 100% discount for individuals, that piece? Yeah, I mean, those are the,
That's what we did. I never
what
really read it. I just didn't remember.
it's a description of what is in ATVSA 9482. The language itself is a little bit wordier because it talks
Okay.
about if somebody does or does not have insurance and,
Reflect, but it reflects.
Have them, but reflects that a little bit.
um,
She guys will get you down a little tiny bit, thank you.
all right, so then no changes to the eligibility, for the individual, no change to the appropriation. Section 3 is this was added on the floor. This is adding in Title I, a definition of behavioral health. Some of you know this is a issue of particular interest to a member of the House. She proposed this, because of concerns about the use of the phrase behavioral health in this bill and in the one we just looked at in the large definition of healthcare services. But it is in those definitions because both of these bills have an external focus that is different from, for example, how we talked about what services insurance covers or what's in somebody's scope of practice in Vermont. And so when we're looking at language that in this case would be interpreted by credit reporting agencies, because some states use the term behavioral health, federal government uses behavioral health, there may be some services that some providers consider behavioral health as opposed to mental health or substance use disorder treatment. We are using the phrase behavioral health in the definition of healthcare services. So this what is a definition being added in Title I of behavioral health, meaning any behavioral condition bearing on health, including stress-linked physical symptoms, patient activation, and health behaviors that can be addressed through support, counseling, change techniques, coaching, and other interventions. As used in the Vermont statutes annotated, the term does not include mental health conditions or substance use disorders. The General Assembly recognizes that using the term behavioral health to describe mental health conditions or substance use disorders has a stigmatizing impact which may deter individuals from seeking health care for those conditions, but also recognizes that some jurisdictions interpret the term to incorporate those conditions and that therefore it may be necessary under limited circumstances to include the term in the definition of healthcare services for the sole reason of avoiding any question about the intended scope of a specific statute. This then relates to Section 4 in the reporting of prohibiting the reporting of medical debt information that prohibits a credit reporting agency from reporting or maintaining in a consumer's file the information about a medical debt, and then defines healthcare services, and we've broadened to use that very broad definition of healthcare services that we looked at in S28 that is already in the existing 1 VSA section 150 that refers to all supplies, care, and services of a medical, dental, behavioral health, into the definition, mental health, substance use disorder treatment, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including medication.
So essentially, we've added this definition here about behavioral health, and now we're using it.
Right, we've actually already used it in the existing definition
I know.
in 1 VSA section 150. It's used in S28. It's used here in S27. And so a definition is added in Title I to address some of the concerns raised by some members that I will also reflect were not not necessarily the consensus view of everyone.
Oh, actually, I'm fine. I mean, I don't know what the committee thinks, but that's a
I'm okay with that.
Senator.
So you said it was a member of the House that has these concerns, and all three of you are like, oh, huh?
Yeah,
I'm like, oh.
Well, we can chat
We'll
later.
chat.
Okay, because I.
Thank you. It's a personal
never
issue.
heard
It's a personal issue.
This being stigmatized at all, we use the term behavioral health all the time.
Understood,
Yeah,
understood, understood.
right.
Remember Hans Selye was the first person who started talking about distress and eustress as a way of affecting our behavior. And our behavior changes regardless of who we are and what we do. It's not necessarily associated with mental health and substance use disorder. So, I'm gonna say that on the floor because I think this helps, I think, internally and perhaps externally. Anyway,
Okay, so no other changes in section 4, or section 5. This is again in section 5, so you're forgetting to update the numbers, sorry. It's just for the markup versions, it's fine in the bill itself. This is adding a little bit of existing language for clarity. In the bill that you sent over, it specifies that the provisions of 9 VSA 2480E, which are the provisions saying nobody can access a consumer's credit report without their consent. The provisions of that do not apply to an organization that is exempt from taxation under section 501c3 of the IRS code when determining eligibility for abolition of medical debt. This clarifies out of some concerns that were raised, provided, however, that the exemption from the provisions of that you have to get permission first do not apply to a tax exempt organization that is a large healthcare facility, so hospital or ambulatory surgical center. There was some concern that this might inadvertently create an opening for hospitals to pull people's credit reports without their permission. So this is
it's always a
closing that.
Yeah.
Then we have the existing chapter on patient financial assistance, to which we have added medical debt and no additional changes there.
Terrific. Thank you. Any concerns here, committee, about sending this with
No.
supporting
This
it?
is on the floor today.
Yes.
I'd like to have a conversation with the behavioral health part because I just don't understand it.
We can have that conversation, but what we'll do is we'll do a little straw poll. And then we'll see where we are and we'll have a conversation. That's, I'll be okay with that.
Ignoring the behavioral health part, yeah.
One has expertise in understanding the difference. That's okay. You have expertise in areas.
Thanks, Jen. Yeah, I'm worried about you.
Don't worry about it. All right, thank you, Jen. I know it went on a little longer, but I think we need to get
No, I
these
know.
things.
I used to get it. When I was a school teacher, I get it.
Done with these bills?
And I felt fine.
All right,
It feels Katie in my house.
all right, we've got a couple, we have two people here on 401. I'd like to wait until Katie gets here so that when we have our conversation, we have it with her.
Okay.
And and I don't know that we're actually gonna get to 91 today.
Oh, there are a lot of people out in the hall.
Yeah, I know that, but
Okay.
we'll look at it.
Should I let them know?